cold in here now. I just turned it up a little bit. Almost 6 years. It's colder than what almost Jeffery was this morning. I haven't been it even back here a little bit, but. Thank you. All right, go ahead, Ms. Hilton.
Thank you. Now, we found that 5A group. If you can start with this first batch and identify both the GBI case number and the state's exhibit number.
GBI exhibit number 5A.02 is state's exhibit number 294 Yankee Alpha 2, submitted by Atlanta Police Department. GBI item number 5A.01 is state's exhibit number 294 Yankee Alpha 1, Atlanta Police Department. GBI item number 5A.03 is state's exhibit number 294 Yankee Alpha 3, Atlanta Police Department. GBI 5A.04 is state's exhibit number 294 Yankee Alpha 4, Atlanta Police Department. GBI item number 5A.05 is state's exhibit number 294 Yankee Alpha 5, Atlanta Police Department. GBI item number 5A.06, submitted from Atlanta Police Department, is state's exhibit number 294 Yankee Alpha 6. GBI item number 5A.07, submitted from Atlanta Police Department, is state's exhibit number 294 Yankee Alpha 7. GBI item number 5A.08, submitted from Atlanta Police Department, is state's exhibit number 294 Yankee Alpha 8. GBI exhibit number 5A.09 from Atlanta Police Department is state's exhibit number 294 Yankee Alpha 9. And state's exhibit number, GBI item number 5A.12 is from Atlanta Police Department and is state's exhibit number 294 Yankee Alpha 10.
And were there additional shell casings with this grouping that you tested?
Yes. GBI item number 5A.19, submitted from Atlanta Police Department, is State's Exhibit 294 Yankee Alpha 11. GBI item number 5A.20, submitted from Atlanta Police Department, is State's Exhibit number 294 Yankee Alpha 12. GBI item number 5A.21 from Atlanta Police Department is State's Exhibit number 294 Yankee Alpha 13. GBI item number 5A.22 from Atlanta Police Department is State's Exhibit number 294 Yankee Alpha 14. GBI item number 5A.23 from Atlanta Police Department is State's Exhibit number 294 Yankee Alpha 15. GBI item number 5A.24 from Atlanta Police Department is State's Exhibit 294 Yankee Alpha 16. GBI item number 5A.25, submitted from Atlanta Police Department, is State's Exhibit number 294 Yankee Alpha 17. GBI item number 5A.26 from Atlanta Police Department is State's Exhibit 294 Yankee Alpha 18. And GBI item number 5A.27 from Atlanta Police Department is 294 Yankee Alpha 19.
And I'll first ask, in total, how many shell casings are these? How many shell casings are these?
There are 19 in front of me, and give me a second and make sure with my worksheet that aligns with the number that I looked at as well. And I examined 19 cartridge cases. 19.
And what were the results of testing those 19 items?
I determined that these .762 caliber cartridge cases were fired from the same firearm.
And was there a list of potential firearms that those could have been fired from?
May I refer to Examiner Voss's report? The report states that they're consistent with being fired in SKS, AK-47, and their variant type 7.62 by 39 millimeter pistols and rifles, and that the list is an investigative lead and is not intended to be an all-inclusive list. And that would also go for the other list of firearms as well.
And earlier you said that the grouping 2A, 2B, 2C, 5B06, and 5B08, those are also consistent with being fired from an SKS or AK-47 style rifle. Is that fair to say?
That was the determination of the type of weapon, yes.
Were that first group, the 2A, 2B, 2C group, and then this last group, were they fired from the same SKS AK-47 type rifle or different?
So that is a comparison of a bullet grouping versus a cartridge case grouping. So like I discussed earlier, I would not have compared the bullet grouping to the cartridge case grouping.
Now, did you have the occasion to test any firearms in this case?
I did do a verification of one firearm to a grouping of cartridge cases to determine if that firearm fired those cartridge cases.
And did you have an identification number, a GBI identification number for the firearm that you tested?
The item number from the GBI for the firearm that I verified was item 1A, and it was also under a different case number than the one we've been referencing throughout this, and that case number was 2015 100 21 21.
And do you know what type of gun that was?
I would have to refer to Examiner Voss's report.
Would that help refresh your memory?
Yes.
Okay.
That was a Smith & Wesson 9mm pistol.
Okay. And which grouping did you test that firearm against when you did your verification?
I verified the firearm, which was GBI 1A, the Smith & Wesson, to the GBI grouping of 5A.10, 5A.13, 5A.15, and 5A.16.
And what were the results of your verification?
I determined that that firearm did not fire those cartridge cases. It was an elimination or an exclusion from that firearm. That firearm did not fire those cartridge cases.
After doing the verification, what would have been your next step, if any?
I know that I also was the peer reviewer on this case, so I would have served as the peer reviewer, which, like I said, it was the primary examination, then verification, then peer review, then the release of the official report. So the next step after I verified it would have been to look over the documentation of the case file.
And did you do that in this case?
Yes.
And what were the results of your peer review? Was it that everything was in order and ready to be released?
So an official report can only be released once it passes all of those phases, and a report was released in this instance. So it would have passed through all of those steps that I talked about.
And did that conclude your involvement in the case once you verified and peer reviewed the items in front of you, as well as the gun that we just discussed?
Other than testifying today, yes.
All right. Your Honor, that concludes my questioning.
All right. Are there defense questions for this witness? Yeah. Okay, go ahead.
Kelly, good afternoon, ma'am.
Good afternoon.
Good to see you again. You and I have met before, is that right?
You said, but I'm sorry, I don't recall.
I'm not memorable over in DeKalb County.
I have testified in DeKalb County, but I try not to remember.
It's not just me. All right, so I've got just a few questions for you if you don't mind. So I heard you testify about everything that you've got in front of you, and you made reference to reports and peer reviewing. Now, when these items of evidence initially came into the GBI crime lab, you were not the first person charged with doing any sort of examination or comparison. Is that correct?
That's correct. I was not the primary examiner assigned to this case.
The person who would have been assigned to the case is someone by the name of Mr. Voss, David Voss. Is that correct?
Correct.
Okay. And so jumping forward a little bit, your testimony ended with you talking about the results being peer reviewed. Are we talking about any examination or comparisons that you did were peer reviewed, or are we talking about Mr. Voss's results being peer reviewed?
So the peer review would have been a collection of all of the documentation within the case file. So looking over the worksheets where, an examiner collects all the data in their case file. So it would have been looking through and making sure that all of the paperwork was in line is what a peer review process was.
Okay. And so in terms of determining, and I heard you refer, when you talk about the different categories or types of guns that those items could have been fired from. You had a list of names, different types of guns. Those are determinations made by Mr. Voss that you then reviewed. Is that right?
Yes, I do have noted in my verification record that I agreed with his determination of the type of weapon.
Okay. So am I correct that these items of evidence, everything that's in front of you, came into the GBI crime lab somewhere around January the 13th of 2015? Does that sound about right?
May I refer to the report from Mr. Voss?
Absolutely.
Thank you. Would you like for me to read the dates specifically off the report?
Oh, if it helps to refresh your recollection by looking at the report as to what date those items of evidence came in, that's all I'm looking for.
So there was a submission on January 13th of 2015 from Atlanta Police Department. There was submission on January 15th, 2015, January 20th, 2015, and January 13th, 2015, according to the report issued.
Okay. And customarily, when these submissions come in to the GBI crime lab, they come in from a particular agency. In this case, it would have been the Atlanta Police Department, correct?
The Atlanta Police Department, and I believe earlier there was also evidence from the Fulton County Medical Examiner as well.
Okay. It would have been on the same case, though. True?
There are several cases represented. We have mainly been talking about one, but I did also mention a firearm from a second gun that I also compared.
And the information that you have, or that the GBI has, when that information comes in, is that it's coming in this case, the items that came from the Atlanta Police Department came from an investigator, J. Thorpe Jr. Is that right?
May I again refer to the report?
Absolutely.
Thank you. J. Thorpe Jr. is listed on the report by Mr. Voss as the requester.
And as these items came in, it made reference to case individuals, and specifically it made reference to a victim, the victim's name being Donovan Thomas. Is that right?
The name Donovan Thomas is listed as a victim on the GBI report issued by David Voss.
And that information, the case individuals, information submitted by Investigator Thorpe also has two subject names, correct?
Yes, it does.
One is Quintez Griffin.
Correct.
And the other one is Kenneth Copeland.
Correct.
And those are the subjects listed on the request for evidence examination or testing that was submitted by J. Thorpe Jr. back in January of 2015.
I don't know when those names would have been applied, but it is true that the report does list those individuals and that J. Thorpe was the requester.
All right. Ms. Kelly, that's all I've got for you. Thank you.
Thank you.
Mr. Sharp?
Kelly, good afternoon. My name is Max Shard, okay?
Nice to meet you.
Nice to meet you. As I understand it, you are an expert in firearms and the mechanics of firearms. Is that fair to say?
More so the microscopic comparison of things, but I also am trained in, how they work and how that leads to the microscopic markings as well.
Okay. And I believe that I want to make sure I'm clear on this. Can you just describe in layman's terms what happens when someone was say I pull the trigger of, we'll say, a handgun, let's say a 40 caliber semi-automatic handgun?
Okay, sure.
Could you explain the mechanics that lead to the firing of a projectile?
Yes. So in this instance, we have a 40 caliber handgun, a pistol. So one of the parts of a firearm can be a magazine, which is somewhere where you can load those 40 caliber pieces of ammunition, your cartridges, into that magazine. And then the magazine can be inserted typically into the butt of the firearm. And I'll use my hand here. So the magazine will be loaded into the bottom of the frame of the firearm. And then that magazine has cartridges in it, but in order for the cartridge to be pulled from the magazine and loaded into the chamber of the firearm, you need to retract the slide of the firearm and then let it go forward again. And as that slide goes forward again, that's what picks up the cartridge from the magazine and chambers it into the firearm. At that point, you can pull the trigger, and like I said earlier, the pulling of the trigger releases, we'll say, the firing pin. That firing pin makes contact with the primer, which here you can see there's an indentation in the silver part here that's indicating a firing pin impression, and that causes the gunpowder inside the cartridge case to be ignited. That's when the bullet starts traveling down the barrel of the firearm. The cartridge case may be ejected if it's a type of firearm that will eject your cartridge cases. And then if there's more for the next shot, if it's a semi-automatic pistol, you would need to pull the trigger again to do your second and third shots. So those subsequent shots, again, the slide would move rearward and pull the next cartridge with each shot from the magazine.
Thank you, Ms. Kelly. Now, I want to go back to the gunpowder. Gunpowder is made of potassium nitrate, charcoal, and sulfur, correct?
The best I recall, yes.
Okay. Would you agree that the mechanics of the propulsion of the projectile, there's several phases once that firing pin hits the primer, correct?
I'm sorry, could you restate that for me?
First, it's ignited, correct? The firing pin hits the primer and ignites.
Yes, it hits the primer, and then there's actually something called a flash hole, if you can see in there. So the igniting of the primer sends that flame into this body of the cartridge case, and that's what then ignites the gunpowder within there.
And once the gunpowder is ignited, it sets off a chemical chain reaction called the combustion phase, correct?
Yes, that is the firing of the firearm, as I stated, does occur because of the combustion.
And that creates heat and pressure within the gun, correct?
Yes, and within the cartridge case specifically, because that's the pressure that's causing that bullet to be pushed out of the mouth of the cartridge case.
Okay, and what causes the bullet to be pushed out, have you ever heard the term release phase?
Release phase?
Yes.
No, I don't
Okay.
think so.
Well, let me ask you this. During the combustion phase, when we have these gases and heat and pressure, that pressure pushes the projectile forward, correct?
Yes, it's a equal and opposite reaction that's occurring. The bullet is being pushed forward out the end of the barrel, and the cartridge case is being pushed rearward towards the back of the slide of the firearm.
And this pressure and combustion is also released from the gun through soot and other particles that leave the gun, correct?
Yes, so the gunpowder, you could see, a plume or sometimes, the smoke or the fire that comes from that cycle happening. The gunpowder particles could also exit out of the end of the barrel as well.
Okay, so the gunshot residue, we'll call it.
Right.
Is that fair to say, gunshot residue or
yes.
soot? Okay. It releases through the ejection port of a handgun, correct?
It could be released through that area as well.
Okay. And the ejection port of the handgun is on the top side of the barrel of the handgun, correct?
It can vary from firearm to firearm where that ejection port is located. So if I may just explain, the ejection port is typically towards the rear of the firearm, and the ejection port is where the cartridge case is being kicked from the slide of the firearm.
And these gases and particles can be released through the ejection port, correct?
They can be, since that is an opening in the firearm. It can be released from there, and also some can be released at the end of the barrel as well.
From the same part of the gun where the projectile comes from, correct?
I'm sorry, can you restate that?
That was very inartful of me. The particles and gunshot residue can be released from the ejection port of the handgun, and also from the same part of the gun that the bullet leaves the gun from, correct?
So out of the muzzle end of the barrel, yes, it could escape from there as well.
Okay. And this combustion of these gases also creates a sound, a bang, correct?
Yes, it can create a noise.
And it also creates a bright flash of light, correct?
It may, and that can vary depending on the type of gun as well.
Okay.
Or ammunition.
All right. I don't want to go beyond what you're comfortable testifying to. Do you know approximately how many microscopic particles are released from the gun when a projectile is fired from a gun?
No, I do not.
Okay. And when we're talking about these microscopic particles, are these the same particles that are ultimately tested for when we talk about gunshot residue testing?
So as a firearms examiner, in the sense of gunshot residue testing, such as on someone's hands after they've fired a gun, that would be more of a trace evidence type of examination. The only time that at the GBI I dealt with gunshot residue was looking at basically articles of clothing for someone who had been shot.
Okay, and you can test articles of clothing for gunshot residue?
Yes, you can.
Okay. And other cloth objects?
You could test other non-cloth objects or cloth objects as well.
Okay, great. And what you're testing for is microscopic particles that contain three specific elements within the same molten particle, correct?
No, as a firearms examiner, we don't look at those elements. That would be more of a trace scientist. Ours is based on visual and chemical testing to determine if things consistent with gunshot residue are present.
Oh, I see. So when you were talking about testing for gunshot residue, you were just talking about trying to find it, not identifying.
Right. I would have done a physical examination to visually look for pieces of gunpowder residue, but not the elemental analysis would be a trace type of examination.
So the questions about the gunshot residue identification would be better for a trace analyst.
Yes.
Is that what you're saying? Okay. Well, thank you for telling me how a gun works.
All right. Does any other defense attorney have questions for this witness? No. All right. Is there any redirect?
Ms. Kelly, we talked earlier about the item 1A from case number 2015-1002-121A. What was the serial number for that weapon?
I would need to refer to Examiner Voss's report.
Would that help refresh your memory as to the serial number?
Yes. The report from Examiner Voss lists GBI exhibit number 1A for case number 2015-100-2121 as a Smith & Wesson 9mm pistol with serial number Hotel Foxtrot Foxtrot 3719. So that's HFF 3719.
And I'm going to approach you with State's Exhibit 470Y. Is that a copy of Mr. Voss's report that you've been referencing on both cross-examination and direct examination?
Yes, this report, State's Exhibit 470Y, does bear the GBI case number. We've been discussing 2015-100-1545.
And would that be the same report that you peer-reviewed, the same items that you peer-reviewed and verified prior to that report being released?
Yes.
Your Honor, at this time, the State would like to send State's Exhibit 470Y into evidence.
No, Nicole, go ahead. Sure. All right. So that's admitted without objection.
And then my last question, Ms. Kelly, do you know the effect, if any,
Turn that mic back on. I think they turned it off when they were conferring.
do you know the effect, if any, does firing a firearm have any effect on fingerprints that may or may not be on a projectile?
I'm not the a fire fingerprint examiner would be best to answer that question, unfortunately.
Thank you so much. I have no further.
Any recross? Okay. Thank you for your time, and you are excused.
Thank you.
With respect to our next witness, I need to just approach you briefly.
Okay.
Your Honor, while Ms. Kelly is approaching, can I clean up the witness stand?
ahead and swear in. Yeah.
You swear affirm testimony you give the truth, whole truth, nothing but the truth?
I do.
Let's see. Thanks, Judge, first name.
First name Michael, Michael. Last name Sprinkle, Sprinkel.
Good afternoon, Mr. Sprinkle. How are you?
I'm doing very well. How are you?
I'm well, thank you. Mr. Sprinkle, would you please tell the jury where it is that you work?
I am a deputy district attorney at the office of the Fulton County District Attorney here in Atlanta, Georgia.
And what are your responsibilities as a deputy district attorney here at the Fulton County DA's office?
I am over the unindicted homicide unit. And what this means is that I receive case files from the various police agencies here in Atlanta, and I review these case files, and I prepare the cases for indictment, which basically means I prepare the charging instrument, that being the indictment, and I also make recommendations as to other investigative steps that we might take prior to presenting the case to the grand jury.
All right. Now, when you said all of the investigative agencies here in Atlanta, is that all of Fulton County that you look at cases for?
Yes, more broadly, Fulton County, not just Atlanta.
All right. Now, prior to working, first of all, how long have you worked as a deputy district attorney over the unindicted homicide unit?
Specifically as a deputy, I was promoted to deputy in late 2021. I've worked in essentially the same capacity since October of 2013, meaning that since I've been in the role wherein I receive case files from the various police agencies in Fulton County and then review them.
Okay. Do you know how many of those case files approximately that you have received since you've been in that role as a unindicted homicide unit and writer? Do you know how many case files you've reviewed since you've been at the DA's office?
Well, over 10 years. I've been doing this over 100. It's going to be over 1,000 case files.
All right. Are all of those homicide case files?
Well, no, they're not all homicide case files.
Now, what other kind of case files then would you have been reviewing?
In my current role?
Yes.
Well, every now and then I'll be assigned some sort of special case or investigation. Off the top of my head, do you want me to get into specifics?
No, I just want you to tell the jury generally what other types.
I think at one point in the past I was specially assigned to a case involving the illegal dumping of tires in abandoned lots across Fulton County. There was a terroristic threats case that I dealt with at one point, just cases like that.
All right. Now, when you get a file from a law enforcement agency in Fulton County, is the file always complete to the point that you're satisfied with presenting it to a grand jury?
No, not always. Oftentimes, maybe not more often than not, but so maybe sometimes is a better word. On reviewing the case files, I find that there are deficiencies in the investigation.
All right. So before we go on to those, any deficiencies or anything like that you might find, would you tell the jury, you started out saying that you have been a deputy DA since late 21 and you've been reviewing homicides since 2013. How long have you been at the district attorney's office total?
Since June of 2011.
And what roles have you held there since that time?
So my first role, my first day of the DA's office was June 21st, 2011. And within 2 days of that, I was placed in what was called at the time the complaint room. Mm-hmm. And I worked an overnight shift. Oh, no, it was like a late afternoon shift. It was like 3 p.m. to 11 p.m., I believe were my hours. And I would essentially just sit there and wait for cases to come in from the various police departments in Atlanta, any kind of felony case at all. They would fax us the police reports, et cetera, and I would read over them. I would draft a summary of the case that would be notarized somehow right there in the complaint room, and this would be provided to a judge at first appearance. And essentially what I did is I would in real time receive the case files, the incident reports essentially from the police officers as they were making the cases.
Okay.
And then I would prepare some preliminary documents to be for first appearance in the morning and then indictment thereafter. I did that for about 3 months, I believe.
Where did you work after that?
2 months, actually. I then was sent to the non-complex trial division.
What does that mean?
Non-complex at that time, and it may be this way at this time too, I don't know, but at that time it was a division within the Fulton County Superior Court that handled or concerned certain felony offenses that were considered lower level in severity than others, such as simple possession of coke.
Your Honor, his background is what I'm establishing, and I'm asking him to just give a brief summary.
All right, well, it's not particularly brief in the summary, so let's get a little bit more brief.
Let's go a little bit more brief. What did you do as a attorney in the non-complex trial division?
I basically just handled the prosecution of lesser felonies like possession of drug and minor theft.
After how long did you stay in the non-complex trial division?
I believe 6 months.
Okay. Where did you go after that?
The trial division.
And what did you do briefly in the trial division?
I handled cases, the prosecution of cases such as aggravated assaults, armed robberies, drug trafficking, that sort of thing.
Okay. And how long did you stay in the trial division?
A little less than 2 years.
After that, is that when you were sort of went into a different role?
Yes, that was in October of 2013 when I was assigned to the major case division and the unindicted homicide role, which is essentially the role that I'm in right now.
Okay. Did you supervise people in October 2013?
No, not at that time.
Did you have any other persons working with you, like investigators?
I did. I had an investigator named David White.
All right. When you received a case, you were talking earlier, and actually, let me just back up quickly. Your educational background, just
well,
majored in.
I major in public policy at the Georgia Institute of Technology, and I got my law degree from Georgia State University.
Now, have you always only worked as a prosecutor, as a lawyer? Briefly telling the jury whether or not you have.
Your Honor, I'm actually going to object to that as irrelevant. It's irrelevant.
Overruled.
Since I've been a licensed attorney, no, I worked for King & Spalding briefly as a document review attorney.
Have you ever worked for an attorney that did criminal defense work?
I did, Alan Begner.
How long did you do that?
2007 to 2010, I believe.
Now, coming back to what you currently do, when you say that you receive cases from law enforcement agencies and you review them for deficiencies at times, please explain to the jury what it is that you mean when you say deficiencies. Well,
I look through the case file and I just looking at not just from a legal perspective, but a common sense perspective. In my judgment, I believe that perhaps there can be more to prove a case at a forthcoming trial, or there should be things that we should do when, investigative tasks that we should take before we present the case to a grand jury and then proceed to trial.
Does every homicide case that you receive, every unindicted homicide case that you receive, include a suspect that has already been identified or warrants have already been taken out for a suspect? Oh.
Rephrase.
With every homicide case that you receive, have warrants already been taken out for a suspect?
Not every case, usually.
What have subjects or suspects been identified in every homicide case that you receive?
Yes, I would say generally there's at the very least a person of interest.
Okay. Under what circumstances do you receive case files where warrants haven't been taken out?
Well, that could be an instance in which the police feel that they, like I said, have at the very least a person of interest in mind, but they would prefer the DA's office to review the case file prior to them. Generally the procedure is the police go to a magistrate and they swear, they provide some testimony to a judge, and then the judge, on hearing that testimony, decides whether a warrant should issue or not. If a warrant issues, then the person that the officer seeks to charge with the crime is presumably arrested on that warrant thereafter. But sometimes the police may feel it necessary to consult with me prior to doing that. So they'll send me the case file and I'll review it, and I'll consult with the police as to what perhaps they or we can do to improve the case and find more evidence prior to their seeking of an arrest warrant or are presenting the case to a grand jury.
Are you a certified law enforcement officer?
I am not a law enforcement officer.
So what types of things, if you would tell the jury, is it that you are able to do that law enforcement isn't able to do when you get these cases that you feel should have more done?
That calls for speculation.
Why don't you rephrase?
Okay. Would you tell the jury some of the steps that you take to obtain more evidence in the cases you receive when you believe that more evidence could be obtained?
Well, I draft search warrants, which law enforcement officers that work for the DA's office review with me. I already mentioned Investigator David White, but there have been others that I've worked with, because the DA's office investigators are certified, post-certified law enforcement officers.
Okay.
And they work with me on the cases. And after I review the case file and discuss the case with them, I'll draft the search warrants and I'll go over it with the law enforcement officer, with the DA's office, and then they'll present it to a superior court judge. And so these search warrants can be for things like cell phone records, social media accounts, et cetera. I can subpoena things on behalf of the grand jury. Certain records for which finding a probable cause is not a condition precedent to receiving the records, like basic cell phone subscriber and incoming, outgoing call data, can be obtained with a subpoena. I can do that. Also, I can also subpoena witnesses to the grand jury, which is something the police can't do.
Do you collaborate with law enforcement officers in further investigating cases, in any of the homicide cases that you receive?
Yes.
Do you discuss with them steps that they might take to strengthen or to better investigate their cases?
All the time, yes.
So are they also capable of drafting these search warrants for cell phone records, social media, and all of the things you just testified about to the jury?
Yes, they are.
So why is it that you then would need to be doing these things with files that you receive from a law enforcement agency?
Well, sometimes, not all the time, but sometimes after the police make an arrest, they feel like their work is done, essentially. I really don't know how to articulate that any better than I just did. And as a result of that, we being myself and the people with whom I work at the DA's office, have to take over the investigation and obtain some of these search warrants ourselves.
When you say social media, cell phone records, and all of the other items that you obtain search warrants for, how do you make a determination, if the law enforcement agency hasn't already gathered them, where to look and what to get?
Well, there's a lot that I can glean from just reviewing what it is that law enforcement did find. Let's say this is not specific to this case at all. This is just a hypothetical. But let's say I obtain a file from law enforcement, and they did obtain some cell phone records. Okay, what I'll do is I'll just load the records into a spreadsheet, and I'll go through the calls line by line, and I'll see a specific call at a certain time, and I'll think, based on some of the information that's contained within the record surrounding that call, or regarding that call rather, that being the date, time of the call, the tower that was utilized by the handset that was placing the call, and the person that was... Right. I'll be curious, let's say, regarding the other person that was a party to that call. And I'll think, you know what, this call was placed by this person like 1 minute after the homicide. I don't know who this person is. I need to find out who that person is. That would be something that I would follow up on. Maybe send a subpoena, or depending on some other things that I may have seen in the records, may even rise to the level of probable cause. So I draft a search warrant to get the tout logs related to that other number, something like that.
Would you tell the jury whether or not you have any experience collecting or listening to jail recordings?
Yes, vast experience.
Yes, sir. Pull that microphone down closer to you.
I think he's talking about me.
Oh, you're talking about, okay, Miss Love, okay.
Would you tell the jury, just for Mr. Harvey, would you tell the jury what experience you have with jail recordings?
Jail recordings are recordings of phone calls placed by inmates at the Fulton County Jail. All calls except for calls made from like contraband cell phones or any other non-regulated phone in the Fulton County Jail are that are placed by inmates are placed from phones that essentially automatically record the phone calls, and the recordings are automatically stored on a server somewhere. Up until very recently, like May of 2024 to be exact, these phones that were in the Fulton County Jail that the inmates would utilize to make these calls were owned and maintained by a company called Securus, Securus. It's now a new company, the name of which I can't recall. But I have access to these jail calls. When it was on Securus, when they're the company that maintained the recordings and the infrastructure that allowed for the recordings, it was there was a website that I would log into. Commandcenter.securustech.net was the uniform resource locator, or URL. I had a login and password, and on logging in, I would be able to search for the jail calls using various search terms, using the search form that was provided to me, and then I could listen to any call that was placed by an inmate from a phone mounted to the wall or through a tablet, and they were all voice over IP calls that were placed.
How would you decide, out of all of the calls that existed at the Fulton County Jail or from the Fulton County Jail, in any particular case, where to start looking for calls of interest?
Well, that is it. There's a lot that goes into that. Okay. So on a typical murder case, I would start with every inmate. Let me back up a little bit. Every inmate is assigned an account number that they have to enter before they place a call from the Fulton County Jail phone. They then have to follow that account number with a PIN. So they type in their account number, they type in their PIN, and then they place a call from the Fulton County Jail, and it debits money from an account that's been set up so they can place calls, because every call costs money. All right. So what I would do is I would first run a list of all phone numbers that the inmate called.
I'm going to object based on relevance, based on bolstering. That'll be my objection.
Your Honor, one, this witness will be talking about certain steps that he took to further the particular investigation of the case that we're here on, and how he did it, and the extent to which the steps and the extent to which he went to find certain things are relevant in terms of how exhaustive his efforts were. So it'll allow the jury to gauge.
Why don't you just ask him if his efforts were exhaustive?
Well, Your Honor, I think it's relevant that the jury understand what he did to narrow down those numbers that he.
Okay, well, let's get to that without there being a treatise on all of this.
Okay. All right, Mr. Sprinkle, without the treatise, can you give us or give to the jury a more condensed version of how you determine what calls you want to look at out of the thousands of calls that exist?
Sure. I basically just compile a list of phone numbers that the inmate called, and then I run each phone number individually, and I look at the date and time that the inmate called the numbers, and based on when that call was placed in temporal proximity to something that I deem significant, I listen to that call, and on listening to it, I determine whether or not it was relevant.
And when you say you run each call individually, what does that mean with the Securus system?
You can search for calls based on phone number only. So you can, in the search field in this form at that website that I said that I log into, you can just type in a phone number and a date range and ask the system to return all calls placed to a certain number by any inmate in the entire facility for a certain time period.
Are inmate names always associated with the PIN numbers, or inmate calls rather, please forgive me. Is a call by an inmate always associated with the PIN number that inmate has been assigned?
No, not at all. It's very common for inmates to utilize each other's PINs, accounts rather, to place calls.
What about when a person is first booked into the jail? Is there an account or a PIN number associated with that person?
No, those calls placed in the booking area, they are not required, nor do they have an account and PIN number to even utilize to make the call. So those calls, they don't need to enter any account information. So the only way you can find calls from the booking area or the lobby area, but for you, you're relevant to your question, the booking area when the inmates first get there, is to search by the phone number specifically.
Okay. Now, do you listen to, when you say that all calls are recorded, do you go and listen to calls between inmates and their attorneys, things that are privileged?
No, and ideally the attorney will have registered their number with the system such that the calls aren't recorded at all, but if I ever see...
Not relevant and is bolstered.
I have a rule. Please go ahead.
Yeah, and if I do see calls from attorneys, then I just don't listen to them, and I just disregard those.
Okay. You mentioned contraband cell phones. Would you explain when you said that except for contraband cell phones, you try to listen to the calls that are made from the jail?
Well, I can't listen to phone calls made from cell phones that have been smuggled into the jail and the inmates are using unlawfully, because those calls are obviously not recorded. Yeah, I mean, they're cell phone calls. Unless there's a wiretap on the phone, I wouldn't be able to listen to those.
We'll come back to the wiretap, but do you ever have access to calls or cell phones, rather, that were smuggled into the jail and used illegally?
Occasionally.
Objection. Asked and answered.
Overruled.
Occasionally, yes. There will be cell phones that are seized from inmates at the Fulton County Jail, and the contents of them are digitally forensically extracted, and I will review those, yes.
When you're talking about them being digitally forensically extracted, could you break that down in lay terms?
So, sure. A cell phone, as I think we all know, has a port on it, generally that you plug a charging cable into to charge it, but also with most, if not all, modern cell phones at this point, that cable can also allow for the transmission and of data to and from the phone. And so when a phone is seized by law enforcement, there's certain software that law enforcement can use to basically plug the phone up to the computer using that same port that can send and receive data. And this software can make an exact copy of the contents of the phone. It's called a forensic data extraction of the phone. And it creates a forensic image, digital image of the phone. And it's meant to ensure that the contents of the phone are not altered at all in this process. And it allows, through the specialized software that law enforcement utilizes, to read the forensic image that is created from this process to inspect the contents of the phone, such as the text messages, images, videos that were filmed and photographed by the phone, etc.
Can you do or find social media content on those extractions as well?
You can. There's subsections of the reports. One of those is or not just Instagram, but social media accounts that are registered to various apps in the phone. So yes, those are in there as well.
And do you ever use those extractions to aid in furthering an investigation into the homicides that you receive?
Yes.
How do you decide what or how to find social media accounts of interest when you're investigating unindicted homicide cases?
Well, there's a lot that goes into that. Are you saying if I were to have a person of interest or anyone really, and I just wanted to find their social media accounts?
Yes. How do you go about determining what social media platforms and to whom or how a person identifies themselves on social media platforms that you find of evidentiary value?
Well, that can be difficult or easy depending on the person. I suppose I would start by just searching for their name on a social media platform. If they have a very uncommon name, then it can be very easy to find them. But if they have a very common name, they can be a little bit more difficult.
Do you use things like phone numbers, or do you use things like phone numbers to narrow that down?
Yeah, so there was a time where if you had someone's cell phone number and you ran it through Facebook in the search field, it would actually just return their Facebook profile. That is Facebook doesn't do that anymore. So that you're right, that was one method. Most social media platforms today, I'm not aware of any that allow you to find, except for Cash App, which I wouldn't really consider a social media platform. But things such as like Snapchat or Instagram or TikTok, et cetera, I'm not aware of any of those that allow you to search by phone number now.
Do you conduct interviews with your investigators to further any investigation of the homicide cases you receive?
Yes, and by that, I mean, my investigator and I will just go visit people at their homes or their places of business, and we'll interview them and ask them questions that we may have about the case.
And when you do that, do you write up a report, or do you in any way include or somehow memorialize that interview?
So there's a couple of things I do. I'll audio record the interviews, and I will generally write a report summarizing the contents of the interview as well.
Do you end up indicting every suspect that has been arrested or for whom?
Objection as to relevance.
Overruled. Do you end up indicting or presenting to the grand jury every suspect that has been identified or arrested in the homicide cases that you receive?
No.
And why is that?
Well, there are times then when on reviewing the case file and
The bolstering.
Y'all want to approach
o'clock, Your Honor?
Y'all earlier, but we're not quite right.
With everybody here, if you want to give, I don't know where that noise is coming from. A little instruction to Mr. Sprinkle is to.
Okay. Yes, Your Honor. I will try to tailor the questions that I ask so that the responses are as focused as we can be, while at the same time allowing the jury to understand and gauge how it is that Deputy DA Sprinkle goes about making decisions in his cases in general, and specifically how and why he did what he did in this case, and how it is consistent with the way that he conducts himself.
Okay, and I mean, essentially, you're a lawyer, so it's easy enough to just tell you this. What we want to avoid is improper bolstering. All right, so just keep that in mind as you're testifying. And obviously, answer the questions that any attorney asks you, but.
And beyond that, with respect to what was discussed at the bench, Your Honor, I'd like the opportunity to.
Sure. So we're going to excuse you for the day, Mr. Sprinkle, and 9 o'clock for you. And of course, if we end up with a different witness, then it won't be 9 o'clock for you, but be prepared to be over here ready to testify at 9.
Your Honor,
Yes, Your Honor.
Before Mr. Sprinkle leaves, I would just ask that you order that no lawyers discuss these matters with Mr. Sprinkle now that he's sworn in as a witness.
Okay, well, I hope everybody knows that that's not appropriate anyway when somebody's in the middle of testifying. So if you need to talk to him about another case, fine, but nobody be talking to Mr. Sprinkle about his ongoing testimony while he's still on the stand.
Your Honor, I believe that the prohibition that Mr. Shard is referring to is akin to the rule of sequestration, and talking to him about what he has already talked about. I would ask that the court allow me to continue to speak with Deputy DA Sprinkle. He is our witness, and he's not, nobody else is, I mean, I know not to talk to him about other people's testimony, but talking to him about things that I'm going to be showing or saying or whatever to him, I don't know that there's any legal prohibition against that, and constraining us from interacting with our witness. He hasn't even been subjected to cross, so we're not trying to tell him what to say, but at this point, there's no difference in terms of his, anything that could be done improperly than there was before he was sworn. So I would ask that the court allow us, and if anyone else wants to talk to him, allow them to talk to him as well. There's nothing that can be, the rule of sequestration isn't going to be violated. So there's not a prohibition against us talking to our witness or any other
I mean, honestly, I think the rule is actually something like, overnight it's okay, something at lunchtime isn't. But essentially you shouldn't be, and he's a lawyer again, but you shouldn't be in the middle of testimony trying to coach him about anything, which and you won't be doing.
Right. But speaking to him about, or asking him about, or showing him evidence that we're going to be doing, or we have, like I said, there's nothing to coach him about. I've just started on the examination, and I don't have any opposition to anybody speaking to him. I don't know if they've done it or not, but there's nothing improper that could be even done at this point. with this witness, just because he has started his testimony. And I would ask that the court allow us to continue to work with and talk with our witness.
And I would object to that. He's on the witness stand, he's sworn. That's every opportunity to talk to the witness about his ongoing testimony. If you hadn't talked to him about what you're going to show him before now, it's too damn late, number one.
All right, Mr. Harvey, you keep talking to opposing counsel, and as you know, practicing law for as long as you have, you're supposed to talk through the court, okay? So can you please try to do that?
Sure. There's every opportunity. You should have taken the opportunity to talk about his testimony before he got on the witness stand. He's a sworn witness now. And the case is Perry versus Leak. It's a United States Supreme Court case in which the government said that a defendant's lawyer can't talk to his own client overnight because it was improper to talk to a witness while the witness was on the witness stand. And the U.S. Supreme Court said, yeah, that's the rule, except for the Sixth Amendment allows a defense lawyer to talk to his own client overnight. So I object to the state or anybody for the state talking to this witness or any witness while they are on the witness stand and testifying.
All right, so I don't think that the case actually limited it just to defense attorneys and defense counsel. That was the reasoning in that case. But, you know, Ms. Love, I mean, be aware that if you talk to him about something overnight, they're going to get up on cross and ask exactly what y'all talked about.
That's fine, and I understand that. And Your Honor, that's fine. And if there's additional case law on any of this, I know that in the morning we're going to be bringing up, we're going to be briefing the court on some other things. Okay. I'll bring it to the courts.
All right. Thank you, Mr. Sprinkle. That actually reminds me, so when Ms. Smith was on the stand, and I may have heard it wrong, but I think that she said that, you know, of course I know this because the trial's been on, you know, live stream. Can everybody please tell or remind anybody that you think might be a witness in this trial to not be watching the live stream before they have testified, to not talk to any witness who has already testified about their testimony, and to not, once they themselves have testified, talk to any other potential witness about what they testified to. Y'all all know that, but not every lay person knows that. So just remind all of your potential witnesses not to be doing that.
Your Honor, I just want to point out that we beg, we admonish, all of that. And I've heard people say, you know, it's everywhere. What am I supposed to? I'm like, turn it off. Correct. But, you know.
Yeah, no, I know. I'm just saying, to the extent y'all can try to control that, please do. All right. What else do we need to handle tonight? Or can? I can leave. Oh, yes, you can. I'm sorry. Yeah, you're out of here. Thank you for the day.
And so, Judge, there was one other. Well, I don't think there's anything I can do about it, though. Now, I'm just going to have to check on the status of our witness who's currently at Grady. But, I mean, I think that I'm not going to speak for the doctor, but there may be a point at which we present something else to the court regarding finding out with more certainty about his
Y'all
condition.
are welcome to do that at any time.
Okay, thank you. Thank you.
Your Honor?
Yes, sir.
Can I, and I could email it to everyone as well, but I have a couple of cases I'd like you to consider we can just start running in the morning. Vega, VEGA versus State. It's 285 Georgia, 32. It's in Division 3. It's a 2009 case. The cases it relies upon are still cited in 2023. And it specifically what we're targeting is where the conduct and the motives of the actor are not matters concerning which the truth must be found i.e. are irrelevant to the issues on trial, then the information, etc., on which he or she acted shall not be admissible. Only in rare instances will the conduct of an investigating officer need to be explained. Otherwise,
Hang on just a second.
Of course.
Sorry, have the deputy going in and out of the jury room, and it looks like some of them are still in there. Go ahead.
Only in rare instances
Shout out
will
to
the
Mac
conduct
and
of
Tony
an
for the
investigating
follow.
officer need to be explained. Otherwise, it is error to permit an investigating officer to testify under the guise of explaining the officer's conduct to what other persons related to the officer during the investigation. The mere circumstance of an officer's initiation and continuation of an investigation without more is not relevant to the inquiry. And the reason, there's also Leslie, by the way, Leslie versus State. That's 355 Georgia Appeal 244. 355 Georgia Appeal 244. It's in Division 7. It's a 2020 case. It says the exact same thing. But
yeah, my understanding of those cases, and it used to be, especially before our new evidence code, that every time there's a hearsay objection when there was an officer on the stand was, oh, it's to explain his conduct, and that's hardly ever relevant. This is A, not just an investigating officer, but B, if Ms. Love, I know you had said some things up at the bench that I think are relevant in responding to this issue of whether, I don't know if it's so much his conduct, but I'm sorry? The practice that he goes about in deciding to sometimes not, I guess, bring an indictment against somebody that had been arrested.
Yes, the decision, the way that he does his job. I mean, yes.
I just want the court to appreciate this then. Then are we allowed to bring in people who've been exonerated by DNA from the Fulton County District Attorney's Office under Michael Sprinkle murder case that has been found to be innocent? Do we get to bring in individual people who say that they were wrongly charged in their murder case after indictment was dismissed? Do we get to bring in people who have pled guilty but will explain, I only pled guilty even though I'm innocent? Because this is just opening up, to me, the DA's office reputation. I could put my reputation in this courtroom as well. I could have a lot of people come in and say, I believe beautiful things. But we don't do that. And that's
which is why, as you know, up at the bench, I instructed Ms. Love to focus and tailor her questioning so that it focuses on what he did in this case.
Okay. I thought we were still talking about okay. And I agree with you. Whatever he did in this case may or may not be relevant, but right now he's talking about, I don't indict everybody that's brought to me. Sometimes law enforcement doesn't do a good job, so I have to pick up the pieces. I don't see why that would do anything.
I don't know why Ms. Love asked that question anyway, but I mean, it's Ms. Love's case. Well, it's the state's case being led by Ms. Love. But one thing that I think this is not the typical case in that the defense actually in this case has a couple of people, I think, who were once indicted for the murder of Mr. Thomas, who no longer are, and we have this other set of people now indicted. And there has been very much suggestion through defense questioning of witnesses thus far, and I don't know, I suspect will be in opening and in closing as well, which is entirely appropriate as a defense counsel to do, but to poke holes in the state's case by saying, these people, law enforcement thought it was them, XYZ, and all of a sudden, it's not. So y'all actually have somebody you're pointing to and saying, this is who ought to be being prosecuted, but they're not. And it's because of, I don't know, whatever reasons y'all come up with to argue. But that, I think, takes it out of the general, well, conduct's never relevant, because neither side should be hamstrung in not being able to counter what the one side is saying about the case. So. Anything else?
If it's tailored, then we can do it question by question. But right now, it's very broad.
Yeah, I agree. And I do not want Mr. Sprinkle sitting up here saying, hey, I'm brilliant, and when I decide, somebody should be prosecuted, it's because I know. Or obviously, he's not going to do that. But anything like that, because his thoughts about it aren't really relevant.
And Your Honor, that is the point that I was actually trying to stay very narrowly focused on, because it's not about his thoughts, but there has been a persistent assertion by way of cross-examination and whatnot regarding it. I won't say impugning, but it kind of is why certain decisions were made. There have been questions posed that have been stricken, that have amounted to they were just after this person, or you ignored this person. And even when we have witnesses that have testified and backed up and been given immunity and said certain things, the suggestion has been made that they were given immunity because the state only wanted to go after X, Y, or Z. And I believe that it is very relevant and important for the jury to be able to gauge what at least was done in this case. And it's not just the decision of the DA's office. This is a person who actually took steps that were of an investigative nature. It is important that they are able to gauge what has happened here in the context of, and I said it at the bench, what he does with each case. This is not no different. And we did say that we were going to tailor it, and we're going to do exactly as the court allowed, go narrower, and then talk specifically after that, after narrowing it down. Generally, is this what you do in each of your cases? So I believe that the court is actually absolutely correct. It would be hamstringing the state's ability to put what this person has done in the context of what they do each time, and then have the defense say, well, he just went this extra mile because he was trying to find information. He went looking for these jail calls. He did all this work because he wanted to find something on this person, versus this is just how he treats an unindicted case. And I would like to, of course, present more case law on bolstering, as the court said that we could in the morning, to argue the point.
Your Honor, can I just invite the court to observe that, to the extent that the court has been listening to the cross-examination and how we've been not presenting our case, it's not our case.
Right.
Our defense is that any challenges to the credibility of the investigation or the investigators has always been in the context of this case. Right? It's been challenging what was done in this case, or what was not done in this case. And so we've been narrowly focused on defending the allegations and the investigation, or what we thought were improper investigations, or targeting wrong people, or targeting certain people. So I think that's relevant. And what Mr. Sprinkle did in investigating this case, assisting the police in this case, sure, that may, like Mr. Steele said, may or may not be relevant. Right? But for him, again, and I don't want to repeat everything that's been said already, but to have him go on and talk about, well, in this case, hypothetically, I may do this because this is why, and for him to go into explaining about the secure system, and this is what inmates do when they get to the jail, when they're down in booking versus elsewhere, all of that is really not necessary for the jury's consideration. It's just not relevant. And for him to talk about other cases really would be improper bolstering. He's bolstering himself. He's bolstering either the work of the DA's office or investigators, and that's just not proper, unless he's talking about what was done in this case.
All right, yes, thank you. I will keep all of that in mind. All right, I will see y'all at, do we even think 8:45 is going to give us enough time? Let's meet at 8:30
We need to be in court at 8 o'clock, Judge.
in the morning, because I just can't get enough of all of you. All right, see y'all at 8:30. Y'all have a good evening.
All right, I'll be back with a fresh.
Oh, that's years.
I'll be back with a fresh review of the Diddy files in a second here. Let me reset my screen.
Sierra got indicted.